All right, welcome back. It's 1 o'clock. Time to begin again. So, yes, I see the comments. The day's kind of dragging. Yeah, we had a different kind of schedule today. We had Chris Stern join us, and that kind of interrupted the schedule. We never had a morning coffee break, so you guys are probably feeling a little burnt out. Well, don't worry. I'll do all the talking. You guys don't have to. So let me moderate the conversation. Continue in our presentation of now creating agency with sellers and buyers. Now that we know what an agency relationship is, how do you create them? Well, written agreements. Now, did you guys see and read the buyer's agency agreement that I asked you to do for your lunch break? And if so, let me ask this question. Who pays the buyer's agent for his services? What would be your question? What would be your answer? The seller. The seller. Everybody agrees the seller pays. Good. Excellent. However, what does it say if the seller doesn't pay the commission? Who pays the buyer's agent's commission? Paragraph goes on to state what happens in that case. Who pays the buyer's agent's or broker's commission in the case where the seller does not pay? Only one person understood and read it? Really? So, okay, two people must have read it. So it says buyer, buyer. Who's broker, Jitendra? Who's broker? The buyer, the buyer, the buyer. Yes, you guys are correct. So what does that mean? Okay, thank you. Appreciate it. Good input. So under normal circumstances, operating in a normal capacity, a buyer's agent is usually and most likely paid by the seller. However, the agreement then states if the seller does not pay the commission, then the buyer agrees to pay it. Now, here's the problem. Now, remember, the seller usually pays, but in the case the seller doesn't pay, then the buyer must pay it. So someone walks into my office. I'm looking to buy a house. Come on in. Hi, my name's Tim Jensen. Blah, blah, blah. Consumer information statement. How can I help you today? I want to buy a house. Okay, great. Here's a buyer's agency agreement. But before I ask you to look at it, I'm going to ask you a question. Number one, are you working with any other agents or brokers to look for a house? Yes, I'm using anybody I can get a hold of who can show me the house I'm going to buy. Fair enough? My second question then is, did you sign any statements or paperwork with the broker in order for them to show you houses? Yes, I signed with each one, 3 of them. And here's my response. Great. Knowing that, I'm sorry I can't help you. Thanks for stopping in. Have a nice day. What? You're going to turn a guy away who wants to buy a house? I have to. Why? This agency agreement is just that. It creates an agency agreement with a broker. That you sign 3 of them means you, Mr. Buyer, if you were to buy a house through me, I'm going to get paid by the seller. Who are your other brokers going to be paid by? Well, I'm not working with them. Oh, but you signed an agreement. And it was for a certain time frame, a certain area. And if I sell you a house in that time frame and in that area, who's going to pay those brokers? Well, the seller would know. The buyer pays the agency fee. What? Yeah, Mr. Buyer, in case you don't know, you may be on the hook for up to 3 commissions to brokers because you didn't buy a house with them, you bought it through me. That's not fair. Didn't you read the agreement? Yeah. Well, didn't you read section 5 where it says if the seller doesn't pay, then the buyer must? But that's not what I understood. Well, that's what it says. And I don't want to be snippy or curt with anybody, but I'm just going to tell them the facts. You did sign these agreements, did you not? Yes. Well, that means if your buyer's agent doesn't get a commission because you bought your house through me, then you have to pay them a commission. This is the importance of knowing what a buyer's agency agreement says and doesn't say. First of all, it created an agency agreement with another broker. Knowing that, I'm now ethically and duty bound to say, I'm sorry, I can't help you because I cannot infringe on another broker's relationship with you. But I don't like the way they work. That's why I came to you. Well, until you get that agency agreement dismissed with that broker, I have to honor that agency agreement. I cannot help you. Now, most brokers would say, okay, I'll show you properties, but you got to work on that guy and get rid of that agency agreement before we contract on a house. Whatever you choose to do. The fact is, by my ethics, my code of ethics, which is located in the back of your book, by the way, it tells me I cannot infringe on another agency relationship. So if this guy tells me he signed buyer's agency agreements with at least one other company, I'd say, I'm sorry, I can't help you. I have to honor the agency agreement you have. And then when you're ready, and after the agency agreement is canceled or terminates, then you come to me and I'll help you buy a house. And buyers don't know about this because the agents don't tell them. They just say, sign this agreement so I can show you houses. They never read them. But that's unethical. Remember, we have ethical things that we have to consider in the real estate business. So in order to create an agency relationship, you must have an agency relationship agreement signed between the client and your brokerage firm. I see people with questions. Go ahead. What's the questions? Who actually would enforce that? The courts would if they got a hold of it. All right, we'll tell you this. Brokers usually hire very smart attorneys. So if they find out that their client bought a house with another broker while they were still under contract with me, I'm suing that guy for commission. And you know what? They'll win in court because the judge will say, did you sign the agreement? Yes. But I didn't know what I was signing. Doesn't matter. You signed the agreement, right? Yeah. Pay the guy. But I don't have any money. Well, then we have to initial a judgment against you. If you don't pay, we'll issue a benchmark for your arrest. What? I'm being very serious here. So you guys who are buyers out in the business, have you signed these agreements? Did you go outside of your broker and look with houses with other brokers? Did they ask the questions? And chances are, no, they never asked the questions. Do they have to pay your fees if you sue? I don't know. You have to talk to court personnel about who pays what in that case. But if you're not sure which area the client wants to move in and it's out of your coverage area they're exploring, well, then the agreement would say, I'm your broker for this area. If you buy outside that area, then it's outside the agreement. It doesn't affect them. Because those other two agents, Marks, weren't asking the right questions and could get themselves into big trouble. What if the original broker who had the original agreement signed went out and sued the other broker for infringement of agency relationship? He'd win in court, and that other broker may lose his license because of it, because he didn't ask the questions. Can you show them houses to explore the area without this contract? Noted. Okay. Okay. So again, guys, thanks for your questions. Good comments. It all comes down to this. Did you ask the questions? Like that first example of procuring cause. Did you ask the buyers if they had any agency relationships with any other brokers? They never asked the question. In that case, it would have been moot, but the fact is that the agent never asked the question. Guys, we have to understand, when someone says, I'm looking to buy a house, we have to ask, are you working with any other agency or brokerages? If they say yes, then follow up with did you sign any agreements with them? If they lie, then they lie, and you can't be held liable for their lie. But if they say yes, you say, that's an agency relationship probably that you created, right? Yeah. Well, I can't interfere in agency relationships with other brokers. It would be wrong for me to do that. Therefore, I have to gently say, sorry, I can't help you. Guys, you have to understand there is etiquette in this business. And there's right and there's wrong. Ask the right questions, get the right responses, do your job, and make money. But if you don't ask the right questions, you may be doing all that work for nothing. And I don't work for nothing. I work for something all the time. Gary, you got a question. What is it? Is there a list of questions we should ask prior in the book, or just those main two questions? Are you working? Did you sign? Your broker is supposed to train you on the dialogue technique and process for doing your job. I was making suggestions about how I would approach it, but it's not written in stone. Your broker may have a completely different dialogue or process. So you have to understand from your broker what their process is and abide by that. Okay, was there anybody else? Mark, did you have a question? No? Oh, is it the same if someone comes me and says they want to sell? Well, first of all, no seller can list with more than one broker in an exclusive listing agreement. Friday, we're going to talk about listing agreements first half of the day. And in every exclusive agency agreement, that means they're authorizing only one broker to list and sell their property. And if that's the case, then only that broker can list and sell that property, market it, advertise, or attract buyers. No other broker can do that. It can only be listed with one broker at a time under an exclusive listing. So I hope I answered your question. All right, let's move on. So creating these agency agreement with a written agreement creates a special agency agreement or relationship. Remember I said that you're going to be hired to do one thing, help me buy a house. That's a special agency agreement to do one thing and one thing only. So this written agreement would be an exclusive listing agreement for a seller and an exclusive buyer agency for a buyer. But even before I ask questions of buyers and sellers, before I discuss anything about real estate, before I show any houses, have any documents signed, I am required by the Real Estate Commission to give to them a copy of the Consumer Information Statement, which is on page 43 and 44 in your textbook. The Consumer Information Statement explains the 4 agency relationships that a broker could have with a client. I'm not required to create agency agreements at this time, just to inform the potential client of how agencies work in real estate in New Jersey. Once they've done reading that, I ask them to sign a copy that they attest to reading the document and date it. Because under New Jersey real estate requirements, I am to give this consumer information statement before any substantial talk of real estate pursues, or before I show any houses, or before I have them sign any forms. They must first be introduced as consumer information statement. So my question is going to be this: of the people in this class, how many of you got the consumer information statement first before your broker either sold or showed a property to you or listed your property? How many? Aaron said, nope, not her, or him rather. Nope, none, never, never land. Bought 3 houses, not once. Okay, this has been in existence since 1995. So good, thanks for sharing, guys. So not one person who answered said yes. That's terrible. That's terrible. I'm assuming because the contract requires it, that your then salesperson said, oh, just sign this, backdate it, so it proves that I gave it to you before we start talking about houses. But then if I assume, you know what happens. So I'd hate to assume anything. But the contract stipulates that you, the buyer and seller, did sign a consumer information statement before any talk of real estate occurred. So if you're lying on a form and the realtor's lying on a form, there's a big problem for a lawsuit that could be developed for some reason. And it's not from consumers, it could be from the Real Estate Commission itself against the salespersons. And I'm not kidding, guys. The Real Estate Commission is very serious about this, or else I wouldn't be discussing it. As part of your licensing knowledge, you must know it to pass an exam. Therefore, it's important. So here's one last time. The Consumer Information Statement is required before any discussion of motivation or financial situation occurs with sellers and buyers, landlords, and tenants. It's not required for short-term rentals, and it's not required for commercial buildings or multi-unit apartment complexes. It's required. So to hear that not one of those people who responded got this consumer information statement before their realtor did something, it's very sad to hear, because it tells me in general, there's a lot of agents that don't know what the hell they're doing out there. So understand, guys, this is required. It's not suggested, it's required. Now that we created agency and talked to you about agency, how do you terminate agency? Okay, good question. Death or incompetency of either party terminates an agency agreement. If the broker dies, any agreement he had is dead because his license is dead. Incompetency, judged mentally incompetent, they can't be responsible for their actions, so any agency agreements they enter into would be null and voided. Destruction or condemnation of the property. Your house, after you list it, is now claimed through eminent domain by a suit of condemnation. And all of a sudden, you want to sell your house, now it's being taken from you. Well, guess what? Your listing agreement is now terminated because a condition changed about ownership since they originally listed. Now you are losing the property to the highway department. There's nothing to sell. The agency agreement is terminated. Mutual agreement is one of the best ways to terminate an agency relationship. Hey, listen, Mr. Broker, this is not working out. Would you agree that we're having problems and it should be, nullified? Yeah, I tell you what, Mr. Consumer, I understand your grief. We're not getting along. Things aren't working out. It may be best if we parted companies, shake hands, cancel the listing, and on you go. The agent could renounce the agreement. Now, the agent, as I have been saying, the only person who's the agent to the consumer is the broker. Remember, you work for the broker as a sub-agent to the client. Therefore, only the broker could terminate the agency agreement. Salespeople cannot. Revocation by the principal. The principal, the buyer or seller, must show cause as to why that agreement should be terminated. Bankruptcy by either party terminates an agency agreement, or completion or fulfillment of the purpose for why the agency agreement was created no longer exists, or it's completed. So I see some questions. What are they? Mr. Wong and Leah, what were your questions? How about expiration of agreement? Yeah, that's a good one. It's not in there, is it? Oh yeah, okay, good. I'll give you a beer on that one, Robert. You got me. By expiration of the time of the agreement, that would terminate the agreement, correct? What does reciprocity mean within the context of agency? I'm unaware of reciprocity in a agency agreement. Can you give me a sample of that, Peter, or where you found that out? Can you direct me to the context that I can review? So it's in the homework question. I don't have those handy. Which chapter homework question? For chapter 3? I do have them. Hang on. Let's look it up. 1, 2, 3. Let's see, reciprocity. Which of the following will not terminate an agency agreement relationship? The answer is reciprocity. And that's the only thing in there that has nothing to do with agency agreements. So the answer to your question is reciprocity has nothing to do with agency agreements. Can you give us an example of completion or fulfillment of the purpose? You asked me to sell your house. We just came from the closing. I sold your house. Now that we did that, the agency agreement is now terminated because we accomplished the task. Don't remember the specifics, but I had to pay my way out of a relationship when a house fell through upon inspection. This was so I could put a bid on another house. I'm not aware of having to pay anything for any reason, unless you can give me an example, Jason. I don't want to tell you what. Maybe this conversation we better be held offline because I don't want to know any personal information or financial information. So let's have that discussion, if you would, offline, and just send me an email or discuss after class, if you would. Yeah, brokers can go bankrupt. I actually did property repossession, foreclosure against the broker. Yeah. So the agent broker can just terminate for no reason. If he wants to, yes. Usually there's a reason, however. Yep, they have the ability to do that. Okay, not seeing any other questions. Let's move on. Now, it gives us an example, buyer as principal, meaning the buyer is the principal that hires the broker to represent their interest. Fair enough. So a buyer's agency agreement would be used, most likely. But payment of fee does not create the agency. Remember, in that buyer's agent agreement, who paid the buyer's broker? The seller did. Therefore, whoever pays the fee doesn't necessarily mean that's the agency that it's based on. Fees can be paid in retainers, flat fees, or from the fee getting it from the listing or the selling broker or the seller himself. Dual agency, as we said, is a representation of both the buyer and the seller in the same transaction without favoring either one. It is legal if we properly disclose and get all proper consent forms signed, but the agent cannot provide the highest level of loyalty. Because if I hear something on the buyer's end that could benefit the seller, I can't tell the seller that. Remember, I'm not allowed to show preference to buyer or seller. I'm working for both in equal capacity. I must treat them equally. All right. Dual agency in New Jersey is legal if the broker discusses legal duties that will or will not be available from the agent. Mr. Seller, I know you want me to represent you as a seller, but would you allow me to be a seller's agent and a disclosed dual agent if the opportunity arises? And if so, this is the legal duties that will or will not be available from me, your agent, if we do that. So understand, guys, having an agency relationship must be explained and what that means to each client. Therefore, you better know what the consumer information statement says. So if I were you, I'd be studying that too. And any other business relationships that might affect the proposed transaction must be disclosed. Oh, by the way, I'm also acting with the buyer as a seller's agent on their property. Well, now I'm duly interested in that client buying this property, so he's motivated to sell his property. You can see where this could go. Therefore, it's always important to have disclosed dual agency agreements signed in writing with all parties involved, so no one can say, but you never told me, and I did this because I thought this was going to happen. And well, here's your signature. Is that your forms? Is your signature on the form? Yeah. Well, then you agreed, right? And as always, advise your clients in a disclosed agency agreement that they should have an attorney if they have any questions about what the process is and how it works. Dual agency and conflicts of interest. Sometimes an agent gets to be familiar with their client. I don't want to go into any weird scenarios here, but let's just say you become friends with one of your buyers or sellers, and then a dual agency agreement lands on your lap for that same client. Because they're your friend or relative or lover or whatever the case is, you now have a clear conflict of interest. How are you going to handle that? And if I was the other party, I'd be saying, no, I don't want you in this disclosed agency. You're in bed with that other client, literally, or whatever. Therefore, you can never be impartial to my interest, or their interest, rather. To overcome that, to avoid any conflict of interest, have your broker represent the other party. You're doing it under the same brokerage license. The broker isn't paid your commission. He'll still get his and you'll still get yours. So understand, guys, there's ways that you can overcome some of these conflicts of interest. Claims of damages when transactions fall through could occur in disclosed agency agreements if one party feels that they've been jilted or taken advantage of or something, or if there was a conflict of interest that you didn't disclose. If the agent purchases the seller's property, then they could never be a disclosable agent. They'd have to be a buyer with the seller present. However, if the client agrees and everybody agrees, not a great way to do it, but you could. Or where the agent has indirect interest in a transaction. It's my mom's house. I'm related to her. I have to disclose that so everybody knows that there's a potential conflict of interest here. Even though it's remote, it could be. So understand, guys, dual agency, it's a fine line you're going to walk, but you must walk it in many cases. So before I move on, any follow-up questions to that before we move on? Please explain the compensation with dual agency. Sometimes the broker can be paid by both, sometimes no. I'm confused. There's no reason to be confused, Deanna. Here, let's look at it as a whiteboard diagram. That's the easiest way to do it. So here's the seller. Here's your broker. Here's you, the salesperson, right? The broker works for the seller. The seller hires the broker to represent their interest. You represent the broker, and the broker hired you to represent their interest. So if the broker charged, let's say, 6% commission, if there was no other broker, broker B, since there's no other broker, then all 6% goes to the broker. And that broker would split their commission with their salesperson according to their commission agreement in their employment agreement. But if we had to split that commission with the broker, then the broker would probably get 3%, and the other broker would get 3%, and then commission splits would be garnered between the broker and their salespersons. So understand, it's always, if you're doing one agency, disclosable agency, one agent represent both, you're going to take the whole commission. But if you're using another brokerage firm to negotiate the deal with, and they represent the buyer, then you're going to split the commission with the other broker, who then splits it with their salesperson. Hopefully that cleared it up. All right, moving on. Disclosure issues, material information. We talked about this, defects in physical condition. These are items important to the buyer they want to know about so they don't make a bad investment. Licensees and sellers must disclose any defects that can or cannot be discovered by reasonable inspection. They're called latent defects if you can't see the problem, like a malfunctioning septic system. You can't see it's not functioning properly. Maybe you can smell it, but you can't see it. But water seepage, sloping floors are clear indicators of a defect in the property. What about underground oil tanks, and if they're used or unused? Do they even know they have them? Buyers should do a home inspection to confirm or disavow all this information through the inspection procedure. Comprehensive loss underwriting exchange report, or the CLUE report, means if the seller's house being sold had insurance claims against it in the past 5 years, there's actually something called a CLUE report. And a buyer can say, can I see a copy of your CLUE report? We had no claims against the property in at least 7 or 8 years. Then there would be no current CLUE report to relate. But if the seller did have claims, then they would possess the CLUE report, which must be passed on to the buyers. Other disclosure issues, off-site conditions. I have to disclose all issues with property if they affect the value or perceived value of property. So, Mr. Buyer, just so you know, there's something occurring in town that could grossly affect the price of this house. Like what? They're putting a new nuclear waste dump in across town. Well, nobody within, 200,000 miles is going to want to live next to that thing. But that could directly affect your property, even though it's not on your property, it could directly affect yours. So disclosure must be complete with off-site conditions. Now, if you're buying new construction, there's an added protection to the buyer in that if an off-site condition exists and is discovered, buyer has an additional 5 days in which to cancel the contract for that purpose. That they discovered something off-site that could infer something to me as a buyer, therefore I'm going to cancel the contract and get an extra 5 days for that. And what about Megan's Law? Well, Megan's Law says this to realtors. Realtors are precluded from disseminating any information about sexual predators in neighborhoods, even if the realtor knows it to be true. What did he say? I said, you're not allowed to tell people about the presence of sexual predators in neighborhoods. But don't I have a duty to disclose? Yes, you do, but you're not allowed to disclose that. But isn't that really important to disclose? The fact is, ladies and gentlemen, the law states that realtors cannot give out information about sexual predators. They can't. It's not allowed. What I do, however, if I'm working with a buyer or seller, is tell them this: before we go out looking at houses today, if you see a house you really like, you owe it to yourself to check the house against the njsp.org website, New Jersey State Police, to see if there's any sexual predators in the neighborhood, because I can't tell you even if there are. So if you find that this house is sexual predators, then say, let's go and look at other houses. I don't need to know anymore. But if you look up the information that's not there, then you can tell me if you want to pursue it, I'll help you buy that house. But I can't stand in front of a house and say, you got to look at the website about this house. I just let the cat out of the bed, and I'm not allowed to do that. So realtors are not allowed to give out information about sexual predators, even if they know it to be true. Questions? By the way, the state of New Jersey determines that a buyer is entitled to know about sexual predators after they close on the property, not before. That's the state of New Jersey law. Whether it seems unfair or not, Angela, that's the law. Can you explain the additional 5 days for new construction? Yes, if you're buying new construction and you discover an off-site condition that could affect your decision, you have an additional 5 days in which to cancel the contract. Catherine, did you have a question? Oh, no. What's the reasoning to withholding the information? I have no idea. It's the law, and I have to abide by the law. Again, my question to pass the exam is not what's the reasoning. My question is, there's a law. How do I react to it? Period. All right, let's move on. Misrepresentation. Now, this is a serious issue. Misrepresentation, whether it's intentional or not, is never a good thing. First of all, let's do this. You may have heard an ad or read an ad that said something like, cozy, quaint bungalow-style home situated on park-like property near major routes. Boy, that sounds perfect. What I'm looking for. I want a cozy, quaint home. In realtor speak, what you just read was cozy, quaint means cozy, small. Quaint, it's completely outdated. It's still got tin cabinets in the kitchen. Bungalow-style home. It's a log house. There's no insulation in it at all. And chances are it's probably termite infested. Situated on park-like property, grass hasn't been cut in 4 years. Near major routes, it's right next to the entrance to the Garden State Parkway. Did they lie in the ad at all? No. But they certainly stretched it, didn't they? That's called puffing. No, it's not what you did Saturday night. Puffing is using gross exaggeration for effect, hyperbole, if you will. Cozy, quaint bungalow-style home. What I really should say is outdated, worn out, uninsulated, microscopic home available. Grass hasn't been cut in 4 years, and it sits right next to Garden State Parkway. Who's going to come and look at that house or call me about it? No one. Therefore, they color those ads up with these descriptive words. It's called puffing. So long as that it's not intentionally misleading to nature of the fact, and using stretching the truth is not actually misleading, you're allowed to get away with it. I don't think it's very ethical, but that's allowable. So if I intentionally tell you something that's not true, House has 7 bedrooms and has 3. That's called intentional or fraudulent misrepresentation. And if I'm found guilty of fraudulent misrepresentation, my license is in jeopardy and I may be paying a huge fine as well. And probably open myself up to a civil or criminal lawsuit for trying to commit fraud. I don't want to do that. Therefore, I must be truthful in my disclosures at all times. There could be negligent misrepresentation where, you know what, if I had dug a little deeper and found out some information, I probably would have realized that that statement might not have been true. Negligent misrepresentation is accidental. I didn't mean to mislead. There was no intent to mislead. It's just that I couldn't find the information, so I assumed something that may not have been there. But if I had done my homework, I may have discovered that that would not be true. So it comes down to intent now. There's fraudulent, intentional misrepresentation, negligent, unintentional, just so we made a mistake and didn't do our research well. Or there could be innocent misrepresentation. And that's achieved when you rely on someone else's opinion as fact and represent it as fact. This guy, the seller, said this, and I relate it to you. I had no intention to misrepresent. In fact, I thought I was getting the truth from the seller, when in fact the seller misled me. That's innocent on my part. I had nothing to do. I could not have discovered the truth if I dug a little deeper because he misled me. So innocent misrepresentation is one where, guys, it wasn't your fault. Somebody else gave you bad info and you relate it as fact. So in the case of liability here, fraudulent misrepresentation is never protected under your E&O insurance because it was intentional. But if it was negligent or innocent misrepresentation, then your E&O errors and omissions insurance will probably cover a claim against you because it was not intentional. So avoid misrepresentation. Never present your opinion as fact. Worst mistake, oh, I believe this is going to, no. Unless you've been in the business for 50, 70 years or more, and not me, I'm not even an expert yet, then there's no way your opinion means anything. And when you do get questions you don't know answers to, do not make up an answer. Good Lord, that's the worst thing you can do. There's nothing wrong with saying, Mr. Client, you know what? I don't know the answer to that question. However, let's consult an expert. Let's get their opinion and find out what they think. That way, there's no misrepresentation whatsoever. And we're doing a factual finding informational thing by getting an expert involved. So whenever you can, rely on experts' opinion or testimony to relay to clients because that's what people believe, whether it's true or not, believe it or not. Now, New Jersey has a Consumer Fraud Act that prohibits misleading, fraudulent, and scam practices. Obviously, you're never allowed to intentionally mislead. But if you do and are found guilty, you may be fined up to 3 times whatever damages the client incurred. That's a lot of money sometimes. Now, there are exceptions to the Consumer Fraud Act where you had no actual knowledge of a thing, so you can't be held responsible for relaying information wrong or right about something. You had no actual knowledge of it at all. Or you made a diligent effort to learn the truth, except the truth was hidden or not disclosed to you for some reason. Or an agent relied on information from a specialist, or the specialist was wrong, therefore the information couldn't have been right. So understand, guys, there are some protections under the Consumer Fraud Act for realtors if they had no actual knowledge of a thing, or they made a diligent effort to find the truth, or they were misled as to the nature of the information. There's also the antitrust laws. Remember yesterday we talked about the antitrust laws. We talked about price fixing and how it's forbidden. There's also another one called customer allocation or market allocation, which is also wrong. Customer allocation would be the same example. Let's take, Catherine Stanovich. You're on the dialogue bar. So Catherine and I are the big real estate brokers in Hackensack. Together, we own 99% of the work here in Hackensack. Everybody comes to us. She's on the west side of the tracks, on the east side of the tracks. Someone from the east side of town comes in it comes into her office, and she says, "I'm sorry, I can't help you. You're on the west side, your east side. You have to go back to Tim Jensen. He's on the east side. He's the broker that handles that area." That's illegal because consumers have the right to use whoever they wish to use as a broker, not who they're being told to use. If you're found guilty of an intentional, illegal price fixing or allocation of customer criminal activity, fines could be as high as, yeah, that's not a misprint, $1 million. Woo-wee. Good thing we don't win that megabucks or Powerball so I can pay that fine. Whew. $1 million. Prison terms up to 10 years for intentionally misleading, or intentionally committing an antitrust violation. You don't want to be anywhere near this stuff, guys. So I'm sorry, Catherine, maybe I missed your question before. Semi-unrelated, but this is a question from the test when I last took it. Where in the listing agreement is Megan's Law located? Where in the listing agreement is the Megan's Law located? It's not, because we can't ask the question. That would be the answer of that if you asked me. What did you come up with, Catherine? I see you trying to respond. Take it easy on me. A quick question or quick one-sentence question would be good, but paragraphs are going to kill me. I know the options for the test were in the beginning, in the closing, and in the other two, I forgot. Well, one of them probably would be it does not apply or something like that, I would assume, because there is no area in the listing agreement that asks for sexual predator disclosures. There is none. All right, let's move on. Ethics, liability, and disciplinable offenses. So you breached your fiduciary duty to your client. You did not do what was right for your client, or you failed to observe your standard of care. You listed a business and you had no idea what to do with the business when you listed it. You caused harm to a client. You had a conflict of interest and did not disclose or recuse yourself. That's a big no-no. Or you misrepresented information intentionally. This is a serious offense. And there's many numerous offenses that could result in fines or suspension or revocation of your license. Guys, none of this activity is acceptable. Know what your agency obligations are and your duties and practice them. Know how to do your job and do it well so you can exercise the duty of care. Always disclose potential conflicts of interest, never misrepresent, and there's a whole slew of other do's and don'ts that I don't want to go into. It's all in your book. Defense against claims of liability. Every broker carries errors and omissions insurance. You will pay your broker for your share of errors and omissions insurance, and every broker is different. So don't ask me how much it is, because every broker is different. Avoid dual contracts at all costs. Dual contracts are highly unethical and highly illegal, and people go to jail for doing it. Dual contracts is where someone creates a contract for a certain price of a sale of a house, then takes that same contract and doctors it with different numbers and represent it to the bank to get funding for probably much more than the house is worth. And if that occurs, that's bank fraud if you're caught. That's a felony offense. That's time in the big house. And around here, that's Sing Sing. You don't want to go to Sing Sing. You just want to be out in the meadows just singing. You don't want to be in Sing singing. Just saying. And always practice ethical behavior. That's easier said than done. Now, in New Jersey and nationwide, you can join certain professional organizations. There are many to choose from. The biggest ones you have to be aware of: the National Association of Realtors, which you will be made a member of once you pay your dues to the local, state, and National Association of Realtors, and you will. And you then is the only time you can call yourself a realtor as a member of the National Association of Realtors. As a member of the National Association of Realtors, you pledge to do your business according to the Code of Ethics, which is in the back of your book. I don't know if anybody's looked at the back of your book, but the Code of Ethics is in there. It's broken down into 3 sections. You have to know what's in there because you're going to be pledging an allegiance to it. Once you become a broker, you can join NAREB or the National Association of Real Estate Brokers. There's also New Jersey Realtors, the state level designation you're going to join, and whatever other designations you wish to get. Now, a designation is an area of specialty or a niche market. If you're starting out in the real estate business, I highly recommend to get the ABR designation, the Accredited Buyer's Representative, which means you have been specially trained with dialogue and technique and process to work with buyers, to understand their motivation, their timing, their financing, their desires, their wants, their changing minds all the time. So it teaches you how to work with buyers. And as an ABR, that puts you above everybody else. You're an accredited buyer's representative. You've been trained in how to work with buyers. So who would you rather work with, Mr. Buyer? Here's this agent, or here's an agent who has been trained as an ABR. I'll take the ABR. Set yourself apart from the herd. Another designation for some of you guys in some of the areas around here are the SRES, the Senior Real Estate Specialist designation, which means you get specially trained in dealing with seniors and their housing needs. And today, it's a changing landscape. But getting that designation means you're very marketable in communities where there are seniors who need to sell or buy houses, because that's who they're looking for, someone who's trained in their housing needs. I personally have the GRI, Graduate of the Realtor Institute. I achieved that back in 1997. It was a 2-year course of study. It cost me maybe a couple $1,000 to do. I had to take courses and pass proficiency exams to advance. But once I did, I achieved the designation of Graduate of the Realtor Institute, which, by just definition, places me in the top 5% of all realtors nationwide as far as product and industry knowledge. And I used that in a marketing campaign for my benefit, and it was very successful. So there's many different designations you can achieve. It's up to you to do. But you really should go at least after one to get a specialist, to become a niche market specialist or some kind of specialist in your area. People will seek you out because of that. Finally, the chapter's over. Was there any follow-up questions before I pull up the review questions for review? No, they don't have an accredited seller's rep designation. No, Gary. There is a buyer's rep, though. See, Mark and no, nobody else? Oh, there we go. What is the difference between a realtor and an agent? Remember, a realtor is you can only call yourself a realtor if you're a member of the National Association of Realtors. Agent means you work for a principal. How much for ABR? Again, you have to find out from your board office and your brokers what the cost of these designated courses are. What is the designation for commercial buildings? There's many of them. You can discuss these all with your broker when you get your license. Well, Tanya, I'm sorry, but we're going right into review questions. I'm not going to hold up because you need to take a potty break. I'm sorry. All right, let's go with the review questions then, guys. And by the way, just as a reminder, the answers to all the review questions are in the book. So don't worry if you miss out. So let me pull up chapter 3 for review. And here we go. Number 1, the legal relationship between broker and seller is generally And from those who did respond, and very few responded, by the way, 82% of you got A correct, special agency. Number 2, a seller cannot be present for the closing. Instead, her parent will sign for her having been given. And some more people starting to respond. Thank you. About 87% of respondents got a correct A, a power of attorney. Number 3, the statement, a broker must be employed to recover a commission for his or her services means. And again, from those who did respond, about 55% of you correctly answered B for boy. Someone must have agreed to pay a commission to the broker for selling the property. Yeah. Number 4, the procuring cause of a sale is. And from those who did respond, 52% of you correctly answered C, sometimes hard to determine. Number 5, a listing may be terminated when either the broker or principal all right, outstanding. 94% of you correctly answered B, goes bankrupt. Now, I know a couple folks answered A, but doesn't help. Getting married doesn't affect your agency relationships or your listings. It may affect many other things in your life, but not real estate matters. So, number 6, when retained by the seller, the broker owes a prospective buyer what? And from those responding, 63% correctly said C, honest treatment. Yes, we must be truthful and honest. Number 7, the salesperson who sincerely tries to represent both buyer and seller is practicing. I thought we'd have 100%, but 97% of you correctly answered C, dual agency. Correct. Number 8, a seller who wishes to cancel a listing agreement in New Jersey. And a good 72% of you correctly answered C, may be held liable for money and time expended by the broker. In fact, I went over that scenario. Guy cancels out last minute. I'm still want to get paid for my time and effort. So, excuse me. Number 9, in New Jersey, the buyer of residential property is entitled to find out about the presence of a convicted sex offender in the neighborhood. And from those responding, again, about 61% of you correctly answered C. After the sale of the property has closed is when the authorities believe a buyer is entitled to know. Number 10. What are buyers who ask to see the owner's comprehensive loss underwriting exchange looking for? And from those responding, 88% of you got it correct. D, insurance claims over the past 5 years. Yes. Number 11, an example of a latent defect is a good. A good 3 out of 4. You 75% of you correctly answered D, malfunctioning septic system. You can't see it, and if it's defective, then it's latent. You can't see it. Better latent than never. Oh, sorry. Number 12, an independent contractor may be paid big thumbs up, 96% correctly answered C, commissions on sales. Well done. Good for you. Number 13, commissions usually are earned when commissions are usually earned when 39% of us got it correct. B for boy, the seller accepts the buyer's offer without contingencies or conditions. Most of you guys answered D, title the property transfers. That's when we get paid. When you get earned is when there's a meeting of the mind and offer and acceptance. That's when you earn the commission. Number 14, even if a proposed transaction does not go through, the broker sometimes may collect a commission where the Excellent. 92% of you got it correct. C, seller simply backed out. Number 15, a salesperson commission on a real estate transaction is %89 of you correctly identified A as the correct answer, paid within 10 days after the brokers paid for the transaction. That is a correct statement. Number 16, to be entitled to collect a commission on a real estate transaction, an agent must. %91 of us correctly answered A, be the procuring cause of the transaction. Yes, good. 17, the seller lists his house with a broker offering a bonus commission of $500 to the agent who brings a good buyer before Thanksgiving. An agent with a cooperating firm effects the sale on November 1st. The buyer agent may collect the bonus from So let me rephrase the question. Who is the only person who's authorized to pay the buyer's agent? And that would be C, the selling broker. Only the buyer's broker can pay the buyer's agent. Remember, you can only be paid by your supervising broker. The buyer's agent works for the selling broker. The listing agent works for the listing broker. You can only be paid by your broker. C would be correct. Number 18, commission rates are set by. And about 70% of you correctly answered D, agreement between the seller and the broker. They would determine what the selling commission would be. Number 19, at a booth in the neighborhood coffee shop, a broker is seated with a friendly rival. Her rival says, did you hear about the firm that's charging a flat fee for selling property? Do you think they'll make it? The broker's proper response is to And from responses generated, we have 68% of you who correctly answered D, point out the rival that there was violation of federal antitrust laws for competing brokers to discuss any aspect of commission rates. D would be correct. 20, a transaction broker represents. "74% of you correctly answered D, no one." Correct. 21. A consumer information statement is required for transactions involving. And 52% of us got it correct. It is B for boy, 1 to 4 family dwellings. As I said, remember, it doesn't apply to commercial real estate transactions. Therefore, A and D can't be possible. And it only applies to residential buildings, 1 to 4 units. So C can't be possible. B for boy was the only answer. Number 22, a dual agent cannot provide advice on. 89% of you correctly identified B as the right answer, the right price to accept. Remember, you're neutral. You can't advise about what's a good price and not. Number 23, the seller may remain quiet about. 97% of us got it correct. C, the previous owner's suicide. That is correct. 24, the duty of loyalty forbids the seller's broker to. 80% of you said C, suggest an offer under the listed price is correct. C, good job. Number 25, when the buyer gives the seller's broker information about possible financial problems in completing the purchase, the broker should. Now remember, it says when the buyer gives a seller's broker information about possible financial problems in completing the purchase, the broker should do what? And about 77% of you correctly answered B for boy, inform the seller immediately. The seller's broker works for the seller. The seller needs to know that the guy's got problems with being able to finance the deal. Number 26, if the agent in the previous question is acting as a buyer's broker, the most correct response for the broker then is to Ooh. Again, I apologize for the misspellings, but it is what it is. If the agent in the previous question is acting as a buyer's broker, the most correct response for the broker is to, and from those who did respond, 50% of us got it correct. B for boy, explain to the buyer that not revealing the problem to the seller may constitute concealment of material defect. Yeah, B for boy. 27, negligent misrepresentation occurs when negligent misrepresentation occurs when B for boy, the speaker should know the statement is false. If they had only done more research, if they had only asked that one other question, they would have known. There was no intent to mislead, just that they didn't know any better and they should have. 28, the term realtor applies only to And from those who responded, 75% of you correctly answered C, members of a private organization. That organization being the National Association of Realtors. And then finally, 29, New Jersey Consumer Fraud Act and about 1 in 3 of you got it correct, 36% to be precise, got it correct. It is C, allows exemptions from liability in some circumstances. Remember there was 3 different exemptions? C is